as long as it qualifies for. There's a prohibition against hearsay. There are also exceptions to the prohibition against hearsay. And so long as this evidence can be admitted under hearsay laws, as long as it qualifies for an exception under the state or federal rules of evidence, we're not really going to pay very much attention to whether or not it violates the Confrontation Clause, so long as it's reliable. We'll just inquire into whether the evidence is reliable. If it's reliable, you don't have to, the government doesn't have to actually present the witness for you to cross-examine. So that was kind of the state of affairs for several decades until the mid-90s, and the Supreme Court, in a case called Crawford, did a big revolution and said, no, actually, the Sixth Amendment Confrontation Clause, Walter Raleigh, blah, 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 we actually care about it. And so confront means confront, literally confront. Physically put the witness in the witness chair, and you get to cross-examine. Bless you. Since then, the court has struggled with how to apply this new rule. And here's what they struggled with. What evidence triggers the Confrontation Clause? And the answer, they've said, right or wrong, is testimonial evidence. So let me give two examples. You know, like I'm walking down the street and I say to my friend, you know, it's sunny outside. That's scenario one. Scenario two, I'm walking down the street and I run into a police officer and I say, hey, just so you know, the guy you arrested last week for murder, you know, Justin Walker, he's guilty and I saw him do it. Okay? Now, these are two, and then now, in scenario one, the friend testifies in court and says, hey, you know, gentlemen of the jury, let me tell you something, ladies and gentlemen of the jury, on November 2nd, you know, Justin told me it's sunny outside. That's the statement. Now, that statement, it's sunny outside, is made by Justin Walker, who's not in court, right? So the defendant cannot cross-examine the person who made that statement that it's sunny outside. So is that a Confrontation Clause violation? No. Because the statement that it's sunny outside is not a testimonial statement. It wasn't made with the goal, with the purpose of providing evidence for a trial. Maybe there's some other rule of evidence that's going to keep it out, but the Confrontation Clause has nothing to say about that because it's not testimonial evidence. So 99.9% of the things we say in life don't count as testimonial evidence. Their primary purpose is not to provide evidence for a future trial. But over here, when I say to a cop, that guy you arrested last week, I saw him commit the murder, that is testimonial evidence. That's made for the primary purpose of providing evidence against an accused defendant at a future trial. So if the government were to introduce the cop, have him put on the witness stand, and the cop says, oh yeah, I ran into someone and that person told me I saw a murder, the defendant did it, that statement by the cop cannot come into evidence. Okay. Does that make sense, the difference between testimonial statements and not testimonial statements? Okay. So just to make sure we're all on the same page, Sharia, if I were to say to the police something like, I'm a Chicago Cubs fan, testimonial or not testimonial?
Not.
Correct. If I were to say to the police that, you know, I saw Elizabeth commit a murder, testimonial or not?
Testimonial.
Okay. So that's where we are. And so then the government could call you to the stand and you could testify that I said I'm a Chicago Cubs fan, even though I'm not there to be cross-examined. That's fine. No Confrontation Clause violation. It's not a testimonial statement. The government tries to call you to the stand and you try to tell the jury that I said I saw Elizabeth commit a murder. That is not allowed. That's a Confrontation Clause violation. And so that's going to be not admitted. Okay? Same page so far? So this question of what is testimonial and not testimonial, I've tried to make it sound very simple to give two extreme examples. But the court has struggled with statements, out-of-court statements, that are kind of testimonial and kind of not testimonial. And that's been where the big debate has been. That's what our case is about. Okay, so let me give some examples. Let's say, and these are actual cases. Let's say that someone calls the 911 and says, I'm being attacked by my domestic partner. Please send police as soon as you can to help me. What do you think, testimonial or not testimonial? There is a right or wrong answer in terms of what the court has said, but there's not really a right or wrong answer because the court may have well gotten it wrong. And
testimonial, because otherwise there would be no reason for the police to show up.
so I think that there's an argument that it's testimonial. The court has said not testimonial in that situation. Why? The purpose of that call was there was an emergency. I wanted the police to come help me, to come keep me safe. I'm the caller. So that was my purpose for making it. My purpose was not, let me provide some evidence to the police so they can use it at a future trial. I might have known that was going to happen, but that's not why I picked up the phone and called. I picked up the phone and called for the same reason I would pick up the phone and call if my house was on fire. Right? There's an emergency, I need some help. I'm not worried about a future trial. Now, imagine that the police come to the house and the domestic partner is in the living room, and down the hall, an hour after the violent incident, a conversation happens in the living room. The domestic violent attacker is in the living room, and then down the hall in the bedroom, let's say 30 yards away, the police are having a conversation with the victim of the attack. And the police are saying, okay, tell me what happened. And the victim says, my domestic partner attacked me. You think that's testimonial or not testimonial? Take a guess. Again, people disagree on this stuff.
I think that was testimonial.
Yeah, so the court...
This is the case.
Yeah, tell us why, sorry.
Just because it gives a reason for what he could be charged with, the assault.
Yep. By that point, the emergency has passed. Debatably. I mean, again, this can be argued from both sides. But what the court said is the emergency has passed at that point. It's not in the midst of the attack. And at that point, the police are not there for the sake of protection. The police are there asking questions in order to gather evidence for a future trial. And so that statement is testimonial, the court says. What do you think? What about guy gets arrested for cocaine possession? The police send the cocaine to a drug lab. Drug lab is run by the government. And the drug lab tests it, comes back positive for cocaine. Guy gets tried, and at trial, the prosecution wants to admit into evidence the test, the drug test, and says we don't need to call the actual forensic analyst who performed the test. So do you think the drug test is testimonial or not testimonial?
I would say testimonial because they're sending it off to try to get evidence to prosecute.
Yep. Anyone else disagree? So the court said yes, that it is testimonial, but it was a split. It was a 5-4 decision. So divided the court. The dissent said this is not testimonial evidence. This is just like a machine doing its thing. So now let's take another case. Again, these are all real cases. There's a DNA test. It's performed by a private contracting lab. Government sends the DNA to the lab. They get the DNA back. DNA says, whatever DNA says, 000111XY, whatever. And I guess it's not computer code. But anyway, the point is, then the government takes the test of the defendant or the suspect, and that matches. Those two DNAs match. So like, aha, like we got the guy. So they go to trial, and they try to admit the DNA evidence from the lab test, and they don't call the person who actually did the lab test. They call it an expert witness who hasn't had any involvement in the test, but is able to say this DNA code that was collected at the crime scene is the same as this DNA code that was collected from the victim. What do you think, testimonial or not testimonial?
Do you mean like the expert witness is what he is saying?
Yeah, so the expert witness comes in and says the DNA that was sent to the lab matches the DNA that was taken from the defendant.
Would you say that it's not because the purpose of the lab test wasn't to prove whether something was illegal or not, but just what it is?
You could say that, and the plurality controlling opinion of the court did say that. The court said this statement, this evidence is not testimonial. Seems very much in tension with that cocaine test I just described, but the court said this is not testimonial, and one of the reasons is that the government ran this DNA test not to target a specific suspect, but just to like find out, like, if anything, it could have been done to limit suspects, right? In a world of 6 billion people, this DNA test will eliminate almost all 6 billion of them. Okay, so that's the law, and I think this is a great topic for the spring because it gives you plenty to argue with on both sides. And again, your argument is the admission of the autopsy report and the death certificate. The autopsy report, by the way, is admitted at trial. Why does the government care a lot about it? They want to show that it was death not by suicide. It's a gunshot, and they want to show that the autopsy shows that it was murder, or the autopsy opines that the death was caused by being shot by someone else. Okay. So as you read the precedents, if you get the impression that they're in tension with each other, correct. If you get the impression that there's not a clear answer to our case, also correct. And if you get the impression that some of the judges who started this revolution, remember how I said they used not to care about the Arbitration Clause, and now they do, got a little buyer's remorse after, the devil in the details, that would also probably be correct. Okay. Homework on Friday is title page. Do this title page. And so how will you do that? You will take a look at the record that I sent, the appellate record and the supplement to the appellate record. And then you will find out, and then I will email you this template, which is a cover page from another case, fake case. And all you have to do is replace everything that you can imagine would need to be replaced. So for example, here's the docket number. That was the docket number for whatever case this was, Scheidel Jones v. Gordon. But we have a different case, so we have a different docket number. So find the docket number in the record. There's a hint on the first page of the record. And put it there. This was in the United States Court of Appeals for the 13th Circuit, which actually doesn't exist. Ours is in an Indiana appellate court. The plaintiff appellee, by the way, in our case, that's the government. Defendant appellant, in our case, that is the defendant, but the defendant's name is not Marion Gordon. On appeal from, write the name of the court that the appeal is from, basically write the name of the trial court. Brief of whatever side you're on, that client's name, and then here, I think this information is also in the record. Obviously not the student name, but whatever firm you represent or something like that. As with all these short assignments, email it by 11:59 p.m. to the Gmail account and bring a hard copy to class. You do not need to bring a hard copy to class when you email every class the writing principle. Yeah.
The attorney is an MD, or is that
That's the client. Marion Gordon is the defendant.
Okay, gotcha. I was looking at the very bottom. It says attorney for appellant, it had a comma, and then, yeah.
Yeah, so yours would be attorney for appellant, whatever the defendant's name is. Bob Smith. Okay, questions? Great. Now, step one for writing your appellate brief is research. So, where do you think you should start research? hear people like whispering the correct first syllable. Secondary sources. Secondary sources. Is that what you're gonna say, Emily?
I was gonna say the case.
Okay, so actually you're both right. If you don't have a lower court case to go on, secondary sources are often the best place to start your research, and they lead you to primary sources. We talked about that in the fall. In this case, though, Emily's right. The case itself has an opinion, a trial court opinion, and that trial court opinion says the government wins, and here's why, and it cites some cases. So that's a pretty good starting point for where to start your research. Start with the cases that the trial court actually cited in support of its decision that there was no confrontation clause violation. And then see where they lead. You can also use secondary sources to see where they lead, and then after you've kind of exhausted those paths, you can go on Lexis and start searching things like confrontation clause and autopsy report and see what else is out there. Confrontation clause and testimonial statements, that kind of thing. I'll give you a bit of a heads up. There are going to be some controlling U.S. Supreme Court cases about what evidence is testimonial. In fact, we just discussed 4 of them. But none of them deal directly, none of the controlling case, none of the, by controlling I mean binding authority, none of those cases deal with autopsy reports. On the other hand, there are some non-controlling opinions out there by various appellate courts that deal with the confrontation clause and autopsy reports. So they're on point, but they're not controlling authorities, not binding mandatory authorities. You want to use both kinds in your brief. When you meet with me to talk about what research you have found, you should treat it like a meeting with a client who has some kind of a background in the law. Either the defendant or the way you would deal with the defendant if it were a general counsel, or if you're the prosecuting side, your prosecuting supervisor. You can bring notes. Tell me what you found. You should work in pairs for the research, but not for the brief. So this semester, for better or worse, and I think from your perspective, probably for worse. I mean, people that work together tended to work well together. Was my impression last semester. But you have to write it by yourself. The brief at the end of the semester. But for the research, work in pairs and meet with me in pairs for the research. If you want me to assign you a partner, just email me today or tomorrow. Say, please assign me a partner. Leave out the please. Okay, so we're going to do 2 things right now. No. We're actually, make 2 slips of paper. Write your name on each slip of paper. And the purpose of one of those is we'll draw.
Okay, thanks.
He thought it was like.
Yeah.
Yours is in dark right now?
It's nice.
Yeah. Oh, so that's the difference.
Can I borrow someone's hat to do like a.
Yeah, mine's the daytime right now.
Did you write my name on it?
Really?
Okay.
I guess I'll give them some instructions.
There.
Oh.
I would aim for about this size or. Yeah, just doing 1 piece of paper. Yeah, just 1 piece of paper. I know I said 2. That was all.
Wow, but they know ours because it's yellow.
Oh, yeah.
Does it have to be white? Oh, okay. All right. And then,
Oh, if you
here,
need
here, wait.
I forgot to research.
I'm trying to stay out
Doesn't
of the
have to be
hat.
white.
honestly.
Look at your pocket, bro. What happened to my name?
Okay. Zach, was Zach the research assistant in last semester for you all, or was it?
Zach and
They
Samantha.
switch off. I'm gonna fold the ones that are figures so they all look the same. Anyway, he forgot about class today. So Can someone
starts
write,
at
type on their laptop
8:45.
as I write these names, as I list these.
Starts at 8:45.
Nah,
This
Okay.
year.
Okay.
Shelby Boyd. And this is a draft order in order to pick which side of the brief you're on. So be thinking about whether you want to be the prosecution or the defendant. And then we're going to go in the reverse draft order so that the losers
He
get something
explained
good.
it. It was
When we pick March Madness bracket, appellate excerpts. You'll see.
it was
Leah
very-
Sharp.
Where they used
How do you pronounce your last name?
That's right.
like the
Alex?
autopsy report to prove whether it was suicide or not. So I guess if you're the prosecution, you're saying
Logan.
the autopsy report should be
It's the drama. Priya.
what's it called? Confrontation arguments or whatever.
Love every minute. Kelsey. All comes down to this. Phil.
Oh, mate.
Sharia. Emily Hart. Emily Lineweaver. Sydney. Shelby Hall. McCalla.
And me. That's me.
Dimitri. Taylor and Elizabeth. It's your reward for writing No Good Deed. But you do get, you'll see, you get first pick. For the other.
Oh.
Okay, so
So we're supposed to
who
write
was first
them
on the
down.
list?
Shelby Boyd.
Okay, and would you mind also writing down what side they picked? Shelby Boyd.
Defense.
Fence. Okay, who's next?
Leah Sharp.
I guess actually I can write it down at this point, so I'm not doing anything else.
I guess prosecution.
Okay.
Oh, Alex.
Defense.
Wait, but now I gotta catch up.
Okay. I can email it to you too.
Okay, but Shelby was defense,
Shelby defense.
and
Leah
Leah was the prosecution.
Alex defense. Logan.
Defense.
Priya.
Priya. Defense.
Bryce.
Defense.
Sam.
This is stuff about the autopsy.
Yeah.
Prosecution.
Kelsey. Prosecution. Phil.
Prosecution.
Sharia.
Defense.
Emily. Hart.
Prosecution.
How many are in each?
Oh, that's a good question. How many are here today? 2, 4, 6, 8. Sorry, 2, 4, 6, 8, 10, 12, 14, 16, 18, 19. So we need 10 and 9.
So we have so far 1, 2, 7. Okay. Emily Lineweaver.
Prosecution.
Sydney. Prosecution. Shelby Hall.
Prosecution.
McKella.
Prosecution.
Okay. Dimitri.
Defense.
Taylor. And that makes me prosecution.
Well, you get a pick, right? Because it's an odd number. You can.
No, because we hit 10.
Or they're 10
Yeah.
defense?
Mhm.
Okay, so you have
Bailey
prosecution.
Williamson, she's not here.
And Jacob.
7.
That's true. So your reward for being here
Okay.
is you get to pick and they don't, so.
Okay. I will do defense then.
Okay.
And who was it that's not here?
Jacob and Bailey.
Jacob.
Okay.
Okay, good. So this is the first time that everyone here has gotten their pick. So it's good. I think the first time in 4 years. So it's good. Usually it's more lopsided. Okay, so that was the first draft, and then so the second draft is going to be for the March Madness bracket. What we'll do is every class you will read something from Supplement 2. What is Supplement 2? It's a collection I put together of some of my favorite legal writers in the world, in the country, whatever. And it's not the whole brief ever, but it's an excerpt, and I think it's like a hall of fame of great legal writers who are out there right now. People like Jeff Fisher, who we're reading today, or who we're reading for next class. Anyway, you'll see. They're great. Talking about this stuff, going over a class is one of my favorite things of the semester. And even, probably even more favorite than that is the bracket. So what we do is each of you will pick one of the readings from this supplement, one of the attorneys. And you will win if they win. You will win the March Madness bracket if the class decides that that writer is the best writer that we read this semester. And so I haven't filled out the bracket yet. It's the same every year. I just haven't done it yet. But it'll be like, Estrada here, and then Estrada will go against Jeff Fisher here, and this will be like Obama here, when he was a practicing attorney, and this will be like Ted Cruz when he was a practicing attorney. So they'll go up against each other, and we'll vote each time. Okay, who thinks that Cruz wrote a better brief? Who thinks Obama wrote a better brief? And then like the winner progresses on, and then you see how it works. So I love it. It's great. So the first thing we have to do is you have to decide which horse you're going to bet, hitch your wagon to. So you can't do that unless you know who the writers are, and even once you know their names, which I'm about to put up here, you can't really do it unless you know something about what their brief is about. Here they are, and so there's 21 here, so that's perfect for this class because there's 21 students, and so and 19 of you are here today. Great. So I'm going to very quickly. You might like take a mental note or something if there's a name in particular or a case that sounds interesting to you, because although you will play a role in whether they win or not, each of you will have a chance before each vote to argue that your writer is better than the opposing writer. There's only so much of an argument you can make if your writer is not as good as if you're going up against like some of these are just they're all like Hall of Famers, but some of them are like Babe Ruth, Ty Cobb, and some of them are like they got in on a close vote. Jeff Fisher writes in this Ohio v. Clark case. Ohio v. Clark is a confrontation clause case. Michael Carvin is writing in this case called Friedrichs, which is about the First Amendment, free speech, and whether you can force people to pay dues to a public sector labor union. Carvin is a private sector attorney. Jeff Fisher runs the Stanford Law Clinic, appellate clinic. Don Verrilli was Obama's Solicitor General, and one of his assistant SGs, John Bash, who's now a U.S. attorney in Texas, wrote the opposing in the Friedrichs free speech case. Chris Landau, this is a great case. First of all, I'll say that Chris Landau wrote one of the best briefs I think I have ever read, but it was such a boring case. I wasn't going to subject you to it. It's a dreadful case, but it was really well written. This case is much more fun. It's one congressman suing another congressman because some random person happened to be listening to a transistor radio or some kind of radio, CB radio, and picked up a conversation between Republican congressmen who were conspiring to break House rules. And so this person was like, hey, this is interesting. I'm going to record it. Then I'm going to send that recording to a Democratic congressman. And then that Democratic congressman was like, hey, I'm going to leak this to the press. And so then, anyway, you'll see. It's a great case.
And that was Landau?
Yeah, so Landau writes that case, writes that brief. Ted Cruz is the most popular member of the United States Senate. No, I'm just kidding. They all hate him. And he writes this. I think it's actually, whether you like him or not, just a really great brief. It's in the case about whether you can display the Ten Commandments on Texas grounds. This is back when he was Solicitor General of Texas. John Roberts, when he was practicing, he writes this case in a really boring EPA brief. It has one really, I think, great paragraph in the facts section. Probably would not advise picking that because it's only a paragraph. You're not going to win the March Madness bracket with that, I don't think. Although, actually, you know what? I think anyway, it's not always a meritocracy, you know, in terms of who wins. It's a vote, you know. It's just like real life. The Estrada brief you read for today, Greg Garr and Jeff Fisher, Jeff Fisher, they went head-to-head in Melendez-Diaz, which is the cocaine confrontation clause DNA test. Sorry, the cocaine test that I was describing earlier. Garr is on the government side at that point, and Fisher was on the defendant side. There's a somewhat heavy emphasis on confrontation clause, which is convenient for you all. Don Verrilli was Obama's Solicitor General, and this is, I think, the conclusion to his brief in the marriage equality case, the Obergefell case. Tom Hungar, private sector attorney. This is a First Amendment establishment of a religion case about prayer before a local school board meeting. This was what last year's spring appellate brief was about. Great writer. Barack Obama is currently the President of the United States. No, just kidding. But anyway, he wrote a brief about voting rights, anyway, he's a brilliant writer, legal writing and beyond. Ruth Bader Ginsburg. I've never really heard of her, because I haven't oh my god, there's a lot. I mean, there's just a lot. There's like a movie with an actress, and then there's like the documentary, and there's like a book, and there's like an exercise book, and there's memes, and it's a lot. Anyway, when she was practicing, she was a brilliant attorney and a path trailblazing attorney, and this was one of the most important cases that she argued. What is it about? It's about whether or not Oklahoma can set, about whether Oklahoma can prohibit, I'm trying to remember what. So in Oklahoma, the law was that you had to be 21 to drink low alcohol beer if you were a man. But you only had to be 18 to drink low alcohol beer if you were a woman. And so that's what the case is about, you know? Great things have small beginnings. Okay, so Ginsburg, Tom Goldstein, this is one of the most fun briefs. Tom Goldstein is a maniac who is just like, he's like a wedding crasher. He's crashed the Supreme Court bar. He's done it brilliantly. Anyway, he writes this case, he writes a lot, which is like fearlessly, and at best fearlessly, at worst recklessly. But this is the facts section, and then the next one by Rosencrantz is from a case called a case about the twins who sued Facebook. What are they called? Yeah, the Winklevoss twins. So this is that case. Rosencrantz represents Facebook. Both of these are fact sections. Both of these are so much fun, the Goldstein and the Rosencrantz. The Goldstein one's not Facebook, it's about, Goldstein's clients are slum landlords who argue that it violates civil rights statutes when the city tries to enforce its housing code. Like, the city comes along and they're like, you really need to have like locks on your doors and heaters that work. It's Minneapolis. Goldstein clients are like, you can't make us do that. That violates the Fair Housing Act. Anyway, he writes this fact section. You have to be a pretty talented lawyer to try to like turn your guys into the good guys in this story. He makes an effort at it. Maybe he was totally wrong, but he makes an effort at it. Then Rosencrantz just goes to town with telling the story of the evil Winklevoss twins and the brilliant, wonderful Mark Zuckerberg. DOJ and the Department of Justice, this is an introduction to a case where the government, kind of sad facts, it's the dad of Al Awlaki, and he says to the government, I think you're planning to drone strike my son, and so don't. I want an injunction prohibiting you from doing that, and the government says you can't get injunction for several reasons. One of them, this is my favorite of their reasons, is they say you're only allowed to bring a suit like this on behalf of someone else if that person doesn't have access to the court. And the government says, well, of course al-Awlaki has access to the court. He's a terrorist in Yemen, but he could come to New York and sue. Like, he could file, you know, like, nothing's stopping him. So anyway, great case, or great intro. So then there are a few judicial opinions. All the ones before this have been briefs. But Scalia, this is an introduction to a case when he was on the DC Circuit about executive power, war powers, basically. When Brett Kavanaugh was on the DC Circuit, he wrote a case about SeaWorld and whether or not OSHA, the Occupational Safety and Health Administration, can prohibit SeaWorld from having an orca show with trainers in the water during the show. The idea was that it jeopardizes the safety of the trainers after the Don Brackow death that was profiled in Blackfish. So if you've seen Blackfish, I highly recommend this brief, or this excerpt, this opinion. Thurgood Marshall, maybe the most important attorney of the 20th century, argued Brown versus Board of Education, went on to the Supreme Court. He writes in Salerno, which is about whether the government can deny someone bail simply because they're dangerous. He says, not in America, not in a free country. Justice Kagan writes a dissent in Williams, which is another Confrontation Clause case, and probably of these the most on point for ours. Williams is the one I described earlier, where there's a DNA test, and the government wants to admit it without actually bringing in the person who ran the DNA test. This is another Roberts writing, although this is when he says a justice, and he just kind of has a little fun with a very short opinion. He writes it like you would, like a Raymond Chandler detective story, potboiler. Okay, that's it. So hopefully you know what you want. Elizabeth, you are first.
Yep.
Okay, so will you write these?
Ginsburg, yeah.
Okay, Elizabeth takes Ginsburg. Great.
Taylor?
Great.
Dimitri?
I'm gonna go the second Roberts.
Here, I'll highlight the ones that people pick. He's a very good lawyer, but I mainly picked this week because you just did the Brady memo the semester before, so something familiar. Okay. How are we on time now? So at 9:41. Okay, good. 2:15. Okay. So so excited. It's hard. I'm so excited. It's hard to transition back to like. But we'll do it. So let me give a little bit of background. Sometimes I'll do this before the reading, but since there was no class before the reading today, a little bit of background on Miguel Estrada, who wrote today's brief. He went to law school with Elena Kagan. They were in the same study group together. He clerked for two different judges. One of them he hated, and one of them he loved. The judge that he hated was Judge Amalia Pierce, who Estrada had a stutter. He still has it to a degree, but not nearly as bad as he did. And she used to use an egg timer and like taunt him with how long it would take him to like spit out what he was trying to say. Then he went on to clerk for Justice Kennedy, and he's argued more than 15 cases before the Supreme Court. He was nominated to be a judge on the DC Circuit, but was filibustered and never got confirmed. My favorite fact about him is he came to the United States at age 17, unable to speak English, and by the time he was 21, he graduated magna from Columbia.
Wow.
So quick learner. So Emily, what was the case about?
The case was a Brady violation case.
Yep, and you give me something beyond that.
The case mainly being Brady, it dealt with the SOFAs, basically the it dealt with the one of the like the witness. It had to basically something was off about the witness, and that was not put in the first notes, but that it was exculpatory evidence.
You got it. You got it. You're doing great. Yeah. So it's a Brady case, and there was a witness, Stolfus. And,
actually, we did this one for the brief last semester.
Oh, really?
The ones I looked at, yeah.
Oh, cool. So Stolfus was a witness used by the government. Turns out Stolfus had made some statements before testimony that were inconsistent with what Stolfus testified to at trial. That those inconsistent statements were not disclosed to the defense, and so the defense says that the 3 parts of Brady, just like you all spent so much time on last semester, favorable, definitely, withheld, definitely. Material, well, that's what that's where the rubber meets the road. So good. So why don't we take 2 minutes, talk to the person next to you, talk about things that you think Estrada did well, things that
I actually but that were struck me.
You have like the Roman numerals, page 7.
Volunteers talk about things that you liked or did not like about it. Yeah.
I really like the headings and subheadings.
Okay.
They broke all that down.
Awesome. Tell me, point us to a page or something.
By page 17 and like top of 19, you can see they have a summary of argument, and then they have like Roman numeral number 1 that goes on to Roman numeral number 2, and then on 19A argument, and they have like the Roman numerals in section A and B for section 1, and so it's just it's nice to be able to take something that's large and jump to, I just want this section. And
Perfect.
See what it is.
Yes, so everything Elizabeth just said, I want to expand on that a little bit, because you will want to do this in your brief. It's more important in your brief than it was in your memo. Number 1, you want to break things down into sections and subsections. That makes things more digestible for your reader. Number 2, you want your sections and subsections to be complete sentences. Why is that? You want your reader to know the message of that whole section. Not just that it's about like the evidence, but that what does he say on page 23? Stolfus's pretrial statements were exculpatory. You want your headings to be argumentative. Not like unfounded arguments, but you want them to summarize the argument that you're going to make. And so ideally, if someone were to read your table of contents, which lists all your headings and subheadings, they could kind of just read a summary of your whole brief, a summary of your argument. Like, you think there's a confrontation clause? Why do you think there's a confrontation clause? Well, I can read your table of contents and basically get an idea of why you think there was a confrontation clause violation. So the one thing, if you look on page 19, that I would suggest that you not do on the headings front is he's got Roman numeral 1 in all capital letters, every word in that. And I think when you have things in all caps, it makes it harder to read. It kind of like a word together. It's like if you emphasize everything, you have in effect emphasized nothing. But other than that, I think I agree with Elizabeth. Very good. Yeah. Did you have more?
Just something that we didn't like.
Yeah.
So like on 17 again, under summary of argument, the second paragraph under there, it's like mostly one huge sentence.
Yep.
But it's sort of necessary where they have a list, so it's nice that in the list you see A, B, C, D, E, and all of that. But it's kind of confusing at the beginning of that list where they describe who the key witness is in the middle of that first intro sentence.
Yep. Yeah. If you haven't, I would suggest going to page 17. I think there's something along here along the lines of what Elizabeth is talking about. Number 1, that paragraph is probably too long a paragraph. It's an intimidating paragraph. It's just so long. Then within that very long paragraph is an extremely long sentence. What's a better way to do that? Maybe bullet points. I'm a pretty big fan of bullet points in briefs. So, you could go up until like the 6th line there, a police detective : and then you could just have A, B, C, D, E, and F bulleted down like that, and then pick up from there. I think that he did a better job. In fact, this is my favorite thing about the brief. On page 28, through 31, and you know, reasonable people can disagree on this, but I think it's very effective to have this basically a chart. On the one side is the trial testimony, on the other side the withheld documents, and you can just see, you can connect. You can't help but connect the dots and see just how inconsistent Stoltzfus's trial testimony was with Stoltzfus's pretrial testimony that the defense didn't have access to. And so, you know, I think to me, someone who reads 28 through 31, you know, you come away with I think the strong impression that, you know, boy, it seemed really important that the government withheld these documents, heading in the direction of material. I saw hands in back.
Yeah, I was just gonna say that. I mean, are we allowed to do kind of that, like freedom to T-chart and stuff, or not?
Yep.
T-chart?
Yeah. No, I encourage it, and you know, also with drafts, you know, there's no harm in experimenting.
Right.
But even for even if there weren't that opportunity to experiment and adjust, I like bullet points. I like charts. You know, to some degree.
I was gonna say like a criticism. I don't know. Like, you use petitioner, and that's kind of confusing.
Yeah, I hate that about this.
Yeah, it's like what do you mean?
I did.
Defendant and appellant.
You should use their names. I think we talked about it last semester, but I think that, you know, you're trying to tell a story, and you're trying to tell a story about why your guy should win, or if you're the government, why the government should win. And good stories have character names. We don't like read A Tale of Two Cities and refer to, you know, the protagonist as the protagonist. I'm showing my English. I don't know who the protagonist of A Tale of Two Cities is. We don't read David Copperfield and instead of always like seeing David or David Copperfield in Dickens's text, like the protagonist went to the store. You know, it's not how you tell a good story. So you'll hear some people say that if you're the government, you should refer to the defendant as the defendant because you want to dehumanize the defendant. I kind of get that as the strategy, but I think that the costs of it outweigh the benefits. The cost to clarity. Okay, I don't want to spend too much time on it. Like I said, I think there are some good things in it. The headings, the chart, I think some pretty good topic sentences. You know, he has a theme. I think we'll talk about that throughout the semester. Almost every reading that we'll do has a theme, sometimes some clearer than others. But you want to have that with your brief. You know, you want to have, you know, as I write this brief, what is the kind of like big picture takeaway message that I want my reader to take away? His theme, I think, is Stoltzfus. Okay, so let's. Any final thoughts? Anything that you just really hated and you just want to air, like into the air of the Festivus airing of grievances. I want to stop the. Okay, so let's listen to about 3 or 4 minutes from the oral argument. And then we'll talk about what he did right and what he did wrong.
One question just on this line. The one question I have is I'd like you to state precisely what the prejudice, in your opinion, is, assuming that you're right on every other matter.
The prejudice as
you have to show cause and prejudice. It's the same question you began to answer to the Chief. I'd like to know precisely what, in your opinion, does the prejudice, because the circuit said there is no prejudice, there was loads of other evidence, and I agree that Donna Tudor is a little shaky, that's one point in your favor, but what precisely is the prejudice?
The prejudice is that a jury of 12 citizens can sleep very, very soundly at night thinking that they sent somebody to death on the word of a perfectly reliable...
No, look, I want to be more precise than that. I take it Mrs. Stoltzfus, assuming she didn't know what she was talking about and hadn't even appeared, what would have happened is you wouldn't have established that your client kidnapped this woman.
Or that
you wouldn't have established what happened at the parking and with the car at the beginning in the shopping mall. But this murder didn't take place then. It took place much later. There were other witnesses, etc. And so that's where I want you to address.
That is not true, Justice Breyer, because there were, in effect, 2 other witnesses. One of them is Donna Tudor, and she has terribly incriminating things to say, which, for the reasons I pointed out in the brief, should be discounted. The other one was Kurt Massey, who all he could say was that he saw my client on the road, it was night, she had the number of people in the car wrong and the race of the people in the car wrong, if one were to credit.
So, what I should do to satisfy myself is read through the record. And if I think there is sufficient evidence, leaving Ms. Dolphus aside and discounting Ms. Tudor, if I think nonetheless there is sufficient evidence, so I have no doubt, or virtually no doubt, that your client was at the place where this woman was killed and participated in a kidnapping, I should then reject your argument.
That is not true.
Okay, good. Why not?
Under Kyle's, the prejudice test, which is the same as the Bagley materiality test, is not a sufficiency of the evidence test. That is my first point. And my second point is that the whole harm of what happened here is that the evidence that the state put forth, which was 1.5 hairs that could have come from any white person, and 2 witnesses who could be heavily impeached but were not.
You left evidence.
What I'm trying to drive at is it that you're saying the prejudice comes from your client being there, or is it that you're saying it's from what he did there?
The prejudice comes from the fact that once the jury heard that he was at point 1 in the state's timeline, he could not but find that he was everywhere else.
Thank you, Mr. Estrada.
Okay, so talk with the person next to you for a minute or two, things that you were surprised by, things you like to do.
Estrada always talked more than him, and you never really got a chance to answer any of his questions.
Yeah, so I think, several things to think about in that respect. Number one is an argument before a judge, and this is true whether there are 9 justices on appeal or whether it's just a single judge at trial for, a speeding ticket. If you're arguing a legal point, if you're, trying to suppress evidence or, arguing a motion or something like that, some judges will be pretty passive and they'll just, you will have filed a brief, but they're not even going to maybe bother to read your brief, and so they just want you to kind of summarize your brief, and then your opponent will summarize her brief, and then the judge will be like, okay, well, you win. But some judges will be very active, and they will have read the brief or read the motion beforehand and the response from your opponent, and they won't want a summary of what they've read. Why would they want a summary of what they read? They've read it. What they want are specific answers to specific questions that were left unresolved by the writings. This is, they call it a hot bench. This is a very hot bench, and very active, lots of questions. So it's good to kind of get in your head that is something you should be prepared for. Again, whether you're arguing a motion before a state trial judge or whether you're arguing a federal appeal. Also think about the difference between arguing to a judge and arguing to a jury. So like most of the things you would see on TV, closing statement to a jury, it's going to appeal to, within the limits, within rules, appeal to jury's emotions, emphasis on the facts. For an argument before a judge or before a panel of judges, they're not going to respond well to appeals for emotions. And I don't think that Estrada was trying to appeal to emotions here, but his answer at one point about the jurors sleeping well at night was, I thought, surprisingly, because again, I think he's a very good attorney, just like way off. I mean, that you guys wrote a Brady memo. That's not a test for materiality. Like, will the jurors sleep well at night? I mean, there's confidence in the outcome of the verdict, things like that, outcome of the trial. But he said, Breyer says, what is the prejudice? And he says the prejudice is that a jury of 12 citizens can sleep very soundly at night. It's not a legal point he's making, and judges want you to be making a legal point. They may want you to talk a lot about how the facts mesh with the law. So you shouldn't make the mistake of thinking, I'm going to go do an argument and not talk about the facts at all, but how the law applies to facts. Okay, other thoughts? What did Shari and what are you all talking about? You told me, I think. That he seems like he never answered it.
Yeah.
Never answered the question. I mean, Breyer asked the same question about 5 times. What's the prejudice here? Now, sometimes Breyer asks it more confusingly than at other times, and as you are pointing out, maybe it's not Estrada's fault that he doesn't answer the question clearly. maybe it's the judge's fault because they didn't let him answer the question clearly. But you go to war with the army you have, not the army you want, and you go to on appeal with the court that you have, not the court that you want. And if the court's only going to allow you a sentence or two before they interrupt you, you got to make the most of that sentence or two. So even if it's the judge's fault to a degree, I think it's also Estrada's fault for not getting to the point faster. And by the way, you'll see this throughout the semester as we listen to these. The better the attorney is at getting to the point, the more latitude the judges will give them to keep going. So we'll hear some attorneys who the judges, they let them talk for a paragraph or 2 paragraphs, or maybe even 3 paragraphs. But that's because the judges have faith that the attorney is not wasting the judge's time. So it's almost paradoxical. Like, the worse you are at getting to the point, the less time they give you to get to the point. And then the better you are getting to the point, you may not even need the extra time, but they give you extra time. Okay. Other thoughts? Yeah, Elizabeth, and then Sharon.
Whenever you said that some judges they'll brief clearly and they just ask you specific questions, and then others want you to summarize, they get sort of a reputation for that being their style, so going in.
Yeah, so before you go into an argument, if you can, you want to prepare for it in part by reading up on the judge or asking around about the judge. And if you work in a firm with other attorneys, then they might have experience before that judge or not. Or if it's a panel, judges on the panel. I remember I wrote, I think the longest legal memo I ever wrote was just a legal memo about the 3 judges on the panel and what we could expect. Anyways, the partner called me in and was like, we just billed the client a ridiculous amount of money for this massive memo. What were you doing? Well, you told me to do it. Yeah, Jared.
How long is our oral argument going to be?
Yeah, someone asked that yesterday. And I think it's about 8 minutes per side, something like that. This would have been part of a 30-minute per side argument. But yeah, it's in the ballpark of 8 minutes, 8 to 12 minutes per side, I think. It seemed like there was one other thing that he said that I wanted to focus on, but sorry. Let's see. Okay, so if this were any reading other than today's reading, you would have been assigned, you would have been matched up with it already. And so part of what you do, if this is yours, is you would argue for why it should win whoever it's competing against in the March Madness bracket. But the other thing that you're responsible for doing is telling the rest of the story. And so if it's your reading for that day, then before class, you should do a little bit of research and find out what happened after the brief was filed. So here's an example. Any guesses on who won? Defendant or prosecution? Prosecution. It's a good guess. With this Supreme Court, it's usually a good guess. So they won, and they won in part because of other evidence that isn't as clear from Estrada's brief. Maybe that's a weakness of his brief, is he sticks so much to his theme that he doesn't grapple with the evidence that cuts against him. But there was a security guard that saw his client Strickler and Henderson at the mall trying to steal a car. Another witness saw Strickler and Henderson driving the victim's car that had been stolen later that night. Strickler gave his girlfriend the victim's earrings, let's see, other things that belonged to the victim were found at the house of Strickler's mom, and then 3 hair samples of the murder scene were probably Strickler's. So there really was a lot of evidence beyond Stolfus, but you can see, why Estrada would want the court to focus on Stolfus and make the argument, well, if Stolfus is not credible, then the prosecution doesn't have a case. Yeah.
What about the armed robbery part? Because they were saying that that's why he got sentenced to death, and that was mostly based on Stolfus or whatever. In order to get a death sentence, you have to do more than commit a murder. You have to commit a murder plus some kind of aggravating factor. And so the aggravating factor here, I think, was that it was murder plus an armed robbery. And so what you might have focused on if you were Strickler on this, actually it's an appeal to habeas petition, is, all right, I'm not even going to try to get my conviction vacated. I just want my death sentence vacated. I want a life sentence instead of a death sentence.
And if I had had this withheld evidence, I would have been able to make a more effective case against the armed robbery. And then if there were no armed robbery, then there would have been the aggravating factor, then it would have been sentenced to death. So part of what he gets asked through arguments is like, what are you here for? Are you claiming that, is your story that your guy didn't do anything wrong, or is your story that like your guy didn't do the armed robbery? Estrada, I think, tries to kind of have it both ways, but he pretty much sticks to the idea that I want the conviction vacated. Beyond that, I've not dug into the weeds enough recently to know. But you are welcome. Yeah.
Oh.
So, and Shari, did we come to you?
Yeah.
Okay, good. All right. So last thing for today is when you email me the writing principle before class, ideally write more than like 2 words, like good topic sentences. I mean, you have completed the assignment if you did that, and there's not going to be a penalty for that. But in terms of like aiming for that extraordinary participation over the course of the semester, consistently saying like there were good topic sentences. For example, on page 12, the paragraph begins blah blah blah. This is a good topic sentence because blah blah blah. I'm not looking for more than like a paragraph, 3 sentences or something. But something more than like 3 words is better than just 3 words. Okay, so normally I would prep you for the next reading that we're going to do, and I will prep you on the facts a little bit, but the law you're pretty prepped on because it's a Confrontation Clause reading, and we talked about the Confrontation Clause at the beginning of the day. But it's from this case called Ohio v. Clark, and what happens is that a kid goes to school, I think it's a 4-year-old, and has signs of being physically abused, and so the teacher or the nurse or someone along those lines asks the kid, like, who did this to you? And the kid says whatever the guy's name is, and it's the boyfriend of the kid's mom, and so that person gets prosecuted. And so it's the government wants to admit this statement into evidence at trial without calling the kid to the witness stand. For you can imagine any number of reasons why the government would not want to do that. And the defense says, "Oh no, you can't call the teacher to the stand and have the teacher tell the jury, the kid told me boyfriend Bob did it," because the defendant has a right to confront the witness against him. In this case, the witness is the testimonial statement comes from the kid, so the defendant wants to be able to cross-examine the kid. And Clark Fisher represents the defendant, the criminal defendant. All right, that's it. See you in 2 days. Elizabeth, will you email all that to me? Thank you.
And I sent too, because I emailed just the prosecution.
Sorry, I don't know why I thought class started at 9.
Well, so I thought it started at 8:45, and everyone else thought it started at 8:30.
8:30.
But we're going with 8:45.
Sounds good to me. Did I miss anything at the beginning? I know you talked about.
Grab that.
Oh yeah, sorry.
No worries.
Yeah, every moment of this class, nature is invaluable.
You were excited too. I like.
Really excited.
Yeah, I was.
Steve Dwyer was on NPR.
Oh, was he really?
Talking about national emergencies.
The wall and all that. He talked about it a little bit on his podcast a couple days ago.
I was like, wait a second, I know that name.
Yeah, I'm from Texas, UT.
But yeah, it sounds like when he's on the podcast that the issue isn't whether the president can declare a national emergency.
It's whether or not Congress can overrule it, I guess. That's what they were talking about on NPR.
I thought he was saying, like, no one can stop Trump from declaring a national emergency. That will trigger any number of powers. But whether or not the power to build this wall is one of those powers is debatable. And I think, in my opinion, is not one of the powers. Yeah.